Good evening. Call the meeting to order. Can I request Commissioner Polito with Pledge of Allegiance?
Thank you. Place your right hand over your heart. Ready, begin. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Roll call, please.
Thank you, Chair and members of the Planning Commission. Tonight's meeting is the special Planning Commission meeting of Wednesday, January 10th, 2024. I will go ahead and do roll call, please. Commissioner Byrd,
Present.
Commissioner Gandhi,
Present.
Commissioner,
Present.
thank you. Commissioner Polito,
present.
Vice Chair Gilheis,
Present.
Chair Javeri.
Present.
All members noted present for the record. Thank you.
Moving on to the next item on the agenda, public comments and suggestions. However, I don't see anyone in the audience, so I guess we can close the public section, public comments and suggestions section. Moving on to the approval of the December 4, 2023 minutes. Does anybody have any concerns or questions? Saying none, may I have the anyone to
I'll make the motion to approve.
I second the motion to approve the minutes from the last meeting.
Thank you, members of the commission. So I have a motion made by Commissioner Gandhi and a second by Vice Chair Gilheis. At this time, I'll go ahead and activate the vote. You may place your votes. I'm waiting for one vote for Chair Javeri.
Yeah.
Thank you. Motion carries by a vote of 5-0.
Next is the consideration of DCA 2024-1 body art business.
Yes, thank you, Chair. This evening, under item 6A, you have review and consideration of Development Code Amendment 2024-1. It's a request to amend the Cerritos Municipal Code related to body art businesses. This item will be presented this evening by Advanced Planning Manager Sabrina Chan. Thank you.
Thank you, Director Aguila.
If we may just have one moment while we work through the PowerPoint presentation. Chair, if we could just call a brief recess while we work through figuring out the PowerPoint. So if you can call for a recess, please.
At this point, there's a brief recess
Thank you.
for 5 minutes. Thank you. the meeting is a call to order.
Thank you, Chair Javeri. I apologize for the inconvenience for having to go into recess due to technical difficulties. At this time, again, I will turn your attention over to Advanced Planning Manager Sabrina Chan for a presentation on item 6A this evening. Thank you.
Thank you, Ms. Aguila. Good evening, Chair and members of the Planning Commission. The item before you tonight is Development Code Amendment 2024-1, a request to amend Title 22 of the Cerritos Municipal Code relating to regulating the regulation of body art businesses in the city of Cerritos. At this time, I would like to turn your attention to the screen for my presentation. Next. To begin the discussion tonight, I wanted to provide the Planning Commission with a brief overview of the city's zoning map and zoning code. Every property in the city of Cerritos is located in and designated in a specific zone, whether it be residential, commercial, industrial, open space, or an area development plan. The Cerritos Municipal Code regulates what uses are permitted and conditionally permitted in each zone, as well as establishes development and at times operational standards within each zone. Next. In January 2023, the city received a letter from an attorney claiming to represent a person interested in operating a tattoo shop at 15969 Payuma Avenue. In the letter, the attorney implied if the city did not approve the tattoo establishment, the city would be violating a person's constitutional rights, notwithstanding any potential impacts to public health, safety, and welfare. The subject property is located in the very northwestern portion of the city and is zoned Industrial Commercial 2 or MC2. Currently, body art businesses, including tattoo establishments, are not listed as a permitted use, permitted accessory use, nor conditionally permitted in any zone within the city. Therefore, the municipal code does not permit nor regulate body art businesses. Next. Although this use is not listed as permitted in the city, case law has set legal precedent on tattoo and body art uses that are important to understand. In 2010, the courts ruled that a tattoo, the process of tattooing, and the business of tattooing are forms of expression protected by the First Amendment to the U.S. Constitution. Therefore, cities cannot outright prohibit tattoo establishments without violating constitutional rights. Then, in 2017, it was determined that cities may, however, establish development standards and use regulations that impose reasonable time, place, and manner restrictions, if done so for the preservation and protection of public health, safety, and welfare from potential negative impacts related to engaging in tattooing. Next. Although protected under the First Amendment, body art businesses may have the potential to negatively impact the public's health, safety, and welfare. For example, tattooing, if undertaken in unsanitary conditions, can potentially lead to the transmission of infectious disease, including hepatitis, syphilis, tuberculosis, and human immunodeficiency virus. In addition, secondary impacts associated with tattoo establishments include the potential for increased crime, negative visual and aesthetic impacts, and decline in property values surrounding tattoo establishments. Next. In response to the original inquiry, case law protecting these uses, and potential public health impacts related to body art businesses, in March 2023, the City Council adopted Urgency Ordinance Number 1040 to establish a 45-day moratorium to allow staff time to review potential impacts of permitting and regulating tattoo establishments, assess existing regulations, and to establish new comprehensive regulations for tattoo establishments. Additionally, the moratorium prohibits any issuance of permits and/or licenses for tattoo establishments or any similar uses. Urgency Ordinance Number 1041 extended the moratorium for an additional 10 months and 15 days for a total period of 1 year. The current moratorium in place is set to expire in March 2024. Next. After a review of all zones in the city's Industrial Commercial 2 MC2 zone has been identified as the appropriate location for potential body art businesses due to the existing infrastructure serving as a buffer for the zone and due to the zone not being directly adjacent to sensitive land uses such as residential uses, schools, and churches. Next. The map on the screen highlights the MC2 zone in blue. Next. A zoomed in aerial map of the MC2 zone is depicted here on the screen. Next. Additionally, DCA 2024-1 proposes to amend Section 22.33.430 conditional uses under the Industrial Commercial 2 MC2 zone to allow for body art businesses as a conditional use. DCA 2024-1 would require a proposed body art business to obtain a conditional use permit, which is subject to Planning Commission and City Council review. Next. To appropriately regulate body art businesses, DCA 2024-1 proposes to amend Title 22 of the Cerritos Municipal Code by adding a new chapter, Chapter 22.46, Body Art Businesses, to establish standards and criteria for the location and operation of body art businesses in the city. In regards to location standards, a minimum distance of 500 feet between two body art businesses is being proposed to prevent overconcentration within the MC2 zone. Additionally, DCA 2024-1 proposes to regulate the hours of operation for these businesses, with no operations permitted between 10 p.m. and 8 a.m. Operational and site development standards for body art businesses, including lighting, special events, signage, minimum age requirements, and noise mitigation, are also proposed. Next. In 2011, Governor Jerry Brown enacted the Safe Body Art Act in an effort to protect body art practitioners and clients. The Safe Body Art Act requires body art establishments to obtain a public health permit and body art practitioners to register with the applicable local enforcement agency. In response to this state-enacted legislation, the County of Los Angeles Department of Public Health established a comprehensive body art program for body art businesses. The county's body art program requires that body art businesses obtain a LA County public health permit, maintain a current infection and prevention control plan, and comply with all public health guidelines for procedure areas and decontamination areas. Additionally, all body art practitioners must be registered with the county and provide proof of completion of a county-approved blood-borne pathogens exposure control training, as well as proof of hepatitis B vaccination. As such, to ensure that public health and safety are protected in Cerritos, DCA 2024-1 requires compliance with all Los Angeles County public health requirements for body art establishments, including obtaining a LA County public health permit and registration of each body art practitioner. All these regulations are being proposed to establish a comprehensive permitting process for the safe operation of body art businesses so that public health, safety, and welfare are protected. Next. The proposed revision to the municipal code under DCA 2024-1 are consistent with the goals and objectives found within the land use, community design, and safety elements within the Cerritos General Plan. Specifically, by adding Cerritos Municipal Code regulations related to body art businesses, the city can continue to preserve, promote, and protect the existing high-quality physical development that characterizes the city while ensuring the public safety of the community. DCA 2024-1 is being presented to the Planning Commission tonight for consideration, and if approved this evening, is tentatively scheduled to be presented to the City Council for consideration on February 8th. If approved by the City Council on February 8th, the proposed ordinance under DCA 2024-1 will be presented to the Council on February 22nd for second reading and adoption, with implementation beginning March 23rd, 2024. Next. So at this time, it is recommended that the Commission review and discuss the proposed ordinance and conduct a public hearing, and waive full reading of and adopt a resolution recommending that the City Council approve Development Code Amendment 2024-1 to amend Title 22 of the Cerritos Municipal Code relating to the regulation of body art businesses in the City of Cerritos. So this concludes my presentation. At this time, staff is available to answer any questions the commissioners may have. Thank you.
Thank you. Do we have any questions from our fellow commissioners?
Can we see the map again to see the zone that we're talking about?
Sure. Yes.
Please. So it's that top left area there that's the blue.
Yes.
Okay. And that's the only area that this code would allow for these types of businesses to be established in the entire city?
Yes.
Okay. The other question that I have Well, I understand that they talk about certifications and health certificates, and does that program that they have, are there requirements there for them to, the practitioners in the body arts, are they required to renew like their certifications? Does anybody from LA County come out to the business like they do for food, right? They have a rating and people come out and they check it and they do inspections. Do the body arts businesses have those types of requirements on their workers?
Thank you, Vice Chair Gilheis. So Los Angeles County does have, it's two parts. They have to get a public health permit and practitioner registration. On the application for Los Angeles County, the practitioner registration, it also allows for renewals. I would have to check with the county for more information on the renewals. I know to get the business running, there are inspections, before a health permit is issued, because they do have to meet requirements of LA County. And I would have to check if the year annual, inspections are conducted. I could check on that for you if you'd like.
Yeah, I was reading in it's Exhibit 4, and it talks about the summary of the Safe Body Art Act. And I didn't get a, excuse me, I didn't get a good feel for, like, are there ongoing checks or inspections, or are the people that actually do the body art, are they required to go through certifications? Like when you go to get your hair done, they have their license that they display, right? So I just wanted to know what kind of regulation was around that. Thank you.
Thank you, Commissioner. Excuse me. And the county is implementing the state laws, was referenced in the staff report, and the body art state law does say that practitioners must register with the local agency, which would be LA County, and that their registration needs to be renewed annually by a process to be determined by the local enforcement agency. So the answer to your question is annually they do need to renew their practitioner's license.
Okay, when you say local enforcement agency, is that the county?
That'd be the county for this, yes.
So the city doesn't have any thing
Cor-
on with
Not,
that.
not
Okay.
for this particular issue.
Okay.
Correct.
So they have to renew for their license, but that doesn't speak to, does the county perform inspections and what frequency? Do they do that to ensure that in fact these acts and these requirements are being adhered to? We don't know that for sure.
We can check on that, on how much they may do self-initiated inspections. But to your point, since this would be amending the city's zoning code, and the zoning code is within the city's jurisdiction to regulate, if anybody who were operating this type of establishment is not complying with our code requirements, which also would include not having a valid license from the county pursuant to the state law and the county regulations, our code enforcement authority and our municipal code enforcement authority would allow the city to inspect and issue citations or violations and to make sure that corrections are made.
Okay, thank you.
That's just physical, like construct of the business inside sort of thing, but not health related.
Well, what they are required to, yes, to answer your question, Commissioner, yes, to the extent that the facility and any signage requirements and any other operations would need to be in compliance with our municipal code. We could visually inspect that and cite that. But we also could cite the establishment, number one, if they're not complying with our municipal code requirement that requires compliance with the county requirements, such as if they don't display a valid license. We could then cite that. And if they're also not conducting, now, if they appear to not be conducting the operations in a manner that would be in conformance with health requirements that the county may impose, I'll defer to the director, but our practice, as my understanding is, we would certainly get the county involved, let them know, and make sure that we have our own code enforcement officials as well as county officials come and inspect to see if there are health compliance if there are health issues not being complied with that the state law and the county law would require.
Thank you, but if they're working at later than 10 o'clock at night as well, right, that would be a problem. We could,
I can go ahead and answer that. Thank
because
you,
I could see
Commissioner
that
Bird.
happen, you know.
Yes, absolutely. If a tattoo establishment was operating later than 10 p.m. and earlier than 8 a.m., that would be in direct violation of the Cerritos Municipal Code, and the city's code enforcement and city prosecutor office can take appropriate action against the violation of the Cerritos Municipal Code.
Commissioner Pulido? Commissioner.
I do. Thank you, Chair. So, this is the first tattoo place that has applied for permit in the city of Cerritos.
I could provide that clarification. So this original inquiry in January 2023 was just that. It was an inquiry. The city did not receive a business license application from the prospective business. It was merely an inquiry, a call to staff, and then a follow-up by the attorney. We have, over the years, gotten inquiries on whether or not if there are any tattoo establishments currently operating in the city, or tattoo establishments operable in the city. And on all of those past inquiries, the answer was no. And it was at this inquiry cited in the staff report in January 2023, where we were made aware of the potential violation of the First Amendment. And so it was at that point that we engaged the city attorney's office and really had a hard look at our municipal code, and which technically initiated the moratorium, so staff could have that 1-year period to look whether or not, in fact, our existing regulations, our existing zoning code was in violation of that First Amendment, and how can we establish regulations that allow tattoo establishments with appropriate regulations to control the development and operation of those uses in Cerritos.
Okay. So this happened to be the first one in the city's history that inquired about setting up this kind of a business in Cerritos, correct?
Not an inquiry. We've gotten inquiries over the years, but this was the first one where we received the inquiry from an attorney on behalf of that business owner wishing to operate on that Piuma property within this MC2 zone.
Okay. So the earlier presentation said that this business was not permitted in the city of Cerritos prior to this.
I can provide clarification. So as mentioned in the presentation, every property in the city of Cerritos has a zone. And in our development code, in the Cerritos Municipal Code, all zones have lists. They have lists of uses that are permitted as a primary use. They have lists of uses that are permitted as an accessory use to the primary use. And then they have lists of uses that are conditionally permitted subject to criteria of the conditional use permit criteria in the municipal code. In every zone in the city of Cerritos, tattoo establishments were not listed as either a permitted primary, a permitted accessory use, or a conditionally permitted use. So tattoos establishments were not listed in the municipal code as a permitted, accessory, or conditional use business.
So technically they were not permitted? So if I had come to you and I said I wanted a tattoo establishment to be set up, the municipal code would not permit me to set up that business in the city of Cerritos prior to this ordinance?
I'll start and then I'll defer to City Attorney Bill Erkey. It was not listed or identified in any zone in the city as permitted.
Yes, and to also follow up on what the director was saying, Commissioner, our municipal code does have a kind of catch-all category where if a use that is proposed is similar to another one that is either permitted or conditionally permitted, there is the ability to make that determination. But as the director was saying, tattoo parlors were not listed anywhere. And this inquiry from the attorney that we referenced last year did make a statement. It was, of course, just based on his own opinion, and we, of course, didn't agree with it, but it was a statement that we had to address, ergo the moratorium, that catch-all would not be sufficient and could still be a basis for a First Amendment challenge. So while our municipal code may have accommodations for tattoo parlors, as was referenced, it wasn't expressly listed, and that's what then led to the inquiry of including tattoo establishments as being listed somewhere in the code to address that concern. And then, if I may, in connection with working with our office and putting together a proposed ordinance, we're aware that there was the state law dealing with body art, and that category, including tattoo parlors. And because there is a state law addressing that overall category of uses, it seemed to make sense to then have that type of use incorporated into the municipal code, because then we'd be covering all bases that have been raised with this, if that makes sense.
It does, thank you. And just to kind of get a better understanding, what other businesses would there be that are not listed and would in the future want to, do you know of any off the top of your head?
Exactly. We don't want to speculate, but every once in a while, we get inquiries from businesses, and a majority of the time, 99% of the time, it is listed or permitted or conditionally permitted in some zone in the city.
So in the event somebody again comes up with a business that they want to start in Cerritos that's not listed in our list of all the zones, we would go through this process again?
Well, the first step would be for staff to review the municipal code, see if it's listed in a zone, then review the comparable uses section, as the attorney was mentioning, to determine if it could be comparable to an existing listed use. And then we staff, in consultation with the attorney's office and the city's executive management team, at that point can determine the next course of action.
And if I may, just to add on to that, Commissioner, not every proposed use or new business or establishment would necessarily have First Amendment implications as well. And because this particular use does, based on federal appellate court case law, that also drives the issue of looking to potentially add it expressly in the municipal code to make sure it's covered.
So
And then I would,
go ahead.
excuse
Sorry.
me, sorry. I would also add that the uses identified in each zone were established well before my time here, but through amendments have been updated as well. But were really established based on potential impacts and compliance, consistency with the goals of the general plan, land use goals, et cetera. So each zone and their permitted or conditionally permitted uses were established with very careful consideration of potential impacts to surrounding uses, including sensitive uses, residential, churches, schools, et cetera. And so the uses, the businesses, we'll call it, the businesses allowed in each zone weren't just kind of willy-nilly picked. It's a very careful consideration for potential impacts of each use, et cetera. And so to add on to what I was saying, first we'd see, is it listed in a zone? Second, we'd decide if it's a comparable use. And then if not, there would be very careful consideration by staff of potential impacts of that not listed business. As Bill was mentioning, this is a different scenario because it's subject to rights under the First Amendment.
Okay. During the presentation, there was also a mention of increased crime with this business as an impact. Would you mind elaborating a little bit more on that one?
If you'd like, I can take a stab at that first,
Please.
Commissioner. The reference was made to crime, or what are referred to under applicable federal case law as, quote, secondary effects that may be attached to certain uses. Where this is sometimes known by the public and by officials is in connection with certain uses like cannabis dispensaries or other uses that may carry with it, for whatever reason, secondary effects related to increased crime that's been documented. And you'd want to make sure that nothing's speculative, but some of this has been documented, as well as potential health and other public safety concerns, such as a need to increase public safety resources for a particular use that may be authorized somewhere in a city. Those secondary effects have been held by applicable case law to be valid for looking at reasons on enacting reasonable regulations, such as time, place, and manner regulations that are equivalent here to the city's zoning code, for allowing those uses, whether they have constitutional protection or not. Here, this one does. But at the same time, maintaining and minimizing those secondary effects that have been known to be attached to certain uses. That's what that was in reference to.
Okay, and so would that kind of factor into the location where it's allowed, in terms of the location in the city where that particular zone?
Yes, excuse me. Yes, Commissioner Gandhi, that was one of staff's consideration in determining where to allow, or in this case, conditionally allow tattoo establishments. As mentioned, the MC2 zone is significantly buffered by the infrastructure. On the east of the zone, east side of the zone is the 605 freeway. On the west side of the zone is the River Channel. Then you have Alondra to the north and the golf course to the south. And so it's significantly buffered, not only by infrastructure, but also away from those sensitive land uses that I mentioned. There's no residential in close proximity to this zone. There's no churches, there's no schools.
Correct.
Yeah, that's a perfect, we're so fortunate to have an area like that that's segregated the way it is. I notice there's I think an ammo or gun store there. I think there's an e-skate, and there's a skate, like electrical skate, I guess, and then a termite company there. I would move to approve Amendment 2024-1. Can't do that? No?
Wait, there are still.
Okay. All right.
At the appropriate time, you can go ahead and make a motion of, we first need to open the public hearing, public comments and suggestion,
Yeah. I still have
and take additional questions. But at the appropriate time, you're welcome to make that motion.
Thank you. You mentioned something about the Los Angeles County Health Department. This being an establishment that deals with or has effect on public health, the jurisdiction for any kind of action that relates to public health would lie with the health department, correct? Not with the city?
I'll take a stab at answering that first, Commissioner, and ask Kristen and Sabrina to follow up, because I know that they did do some additional research in checking out the county's regulations. I think maybe the best way to start answering the question is think of restaurants that do have concurrent county jurisdiction over health inspections and making sure that they are meeting health requirements for serving food. But restaurants within the city of Cerritos must comply with our municipal code zoning requirements, and this would work similar to that, where we would have land use authority because this establishment, at least the one that was, the site that was, the address that was cited by this one particular inquirer, as well as this zone, is within the city of Cerritos, so our land use authority and zoning code would govern the authorized uses. As far as the practitioners and those that are engaged in any body art services, they would need to, like a restaurant, get a license and a permit and approval from the county, because they are the jurisdiction that we defer to for those type of certifications and making sure they comply with health requirements vis-a-vis the state law that then has delegated that to local jurisdictions to oversee.
And then I would also add that, like any business, excuse me, like any business here in the city of Cerritos, they would also be required to obtain a City of Cerritos business license, which is subject to renewal each year. And it's at also the business license issuance and renewal process that staff could request or would request a proof of the public health department permit, even though it's also going to be required to be displayed in the window, proof of the public health department certificate, and proof of the practitioner licenses as well.
Thank you for that clarification. My question is more related to somebody, we can call it a customer or patient or whatever you want to call these people who are getting the tattoo, something to do with the health of the patient or health of the customer. Do we have any jurisdiction on it? Because let's say there's an outbreak of something at that particular location. There's nothing in the code that allows us to go and do anything about that. That would be the health department taking care of it, right?
Yeah, the short answer on that is yes, that would be a health department issue. And again, the city's interest in this is land use regulation and authorized land uses for an establishment. If there were an outbreak, like, for instance, COVID or anything that might be an infectious disease outbreak, that does generally fall under the jurisdiction of the counties and their health departments, unless a city has its own health department, but very few do. Then it would be within the jurisdiction of the county. And there's a whole set of state law and county laws that then would kick in that type of, specific situation. But again, what we're dealing with here is just the authorization in an area of the city per our land use authority and permitting requirements that the city can require in order to actually have an establishment.
What we're considering today, the ordinance part of it, there's nothing in there that the city can do if there is a infectious disease outbreak. Does that statement ring true?
We could, for instance, it's not like we are helpless in not doing anything. The city actually, like the county, and again, referencing back to COVID, because we're all fairly familiar with that since it just recently occurred, the city does have authority under state law to issue a local emergency that could involve an infectious disease or health risk. But the county and the county health agency is usually the authority that cities in LA County will defer to on implementing any response. What the city can do as far as if there is an emergency, if there's an outbreak, and again, this is kind of speculative, but if there is an outbreak, the city can declare a local emergency. They can quarantine, just like the county can quarantine, just like the state can quarantine and address a serious outbreak in that manner if necessary. But in the ordinary course, if there were a situation where an individual may have a health issue and then there's some kind of health issue that results from that within the city, what we would do is most likely contact the county health agency, and work with them on addressing the issue. I gave an example of kind of the extreme situations in declaring local emergencies, but we do have the authority to do that. I don't know if that would necessarily ever arise in this type of situation, but there is that authority.
And then I'll also go ahead and add, for context, I'll refer to COVID as well. During COVID, the city partnered with LA County and established, we'll call it a partnership, but a relationship with the county so that if Cerritos residents, Cerritos businesses, et cetera, were concerned about a business operating in the city in violation of, at that time, state as well as county COVID mandates and requirements, we picked up the phone and had a direct contact at the county for such reporting. I do want to note that in advance of presenting this information to the Planning Commission this evening and putting the information in the agenda report about this county process for compliance with the Safe Art Act, city staff did reach out to the county, and the county is very amenable to having a similar partnership with the city and working together to ensure compliance at a local level, city, with the assistance of the county's level, at the county level for compliance with state requirements. And so in lieu of just attaching this information, we have already contacted the county. They're on board with such a relationship with the city for this effort.
Thank you for that explanation, but maybe, I'm sorry, I don't mean to beat a dead horse, but what I'm trying to get to is, if there is a business that violates county health, whatever it is. So let's say there was a breakout of hepatitis at one location, and the county health department says, yep, there's a location that caused the outbreak. Can the city go and say, we're going to shut this business down because of that? Because it lies with the jurisdiction, lies with the health department. And is there anything in this ordinance that says we can do that?
Well, I'll take a stab at answering that, Commissioner, in two parts. First of all, the county would most likely shut that down if necessary. They would have the authority to do that under state law, granting them public health authority. Now, secondly, we do have in our proposed ordinance, and to the extent we may need to make it more clear if necessary, we do have the requirements of obtaining permitting and licensing from the appropriate agency and applicable laws that, and if you are not, and if someone who is operating one of these establishments does not strictly comply, we would have a basis in our own municipal code to then cite them. For instance, in draft section 22.44.040 in operations, the body art, it provides that body art businesses shall comply with the following operational standards, and there is the reference in subsection 2 applicable laws, which references the Safe Body Art Act, which is the state law, as well as a couple penal code sections, but that state law is what's implemented through the county. So if anybody who is operating one of these establishments is not in compliance with the county's requirements, that in and of itself would also be a violation of our municipal code. If there is a violation of our municipal code, we could respond appropriately as well, including by citing them for a municipal code violation, potentially revoking a permit, going through the process to do that for violating provisions of the code. So again, to answer your question in two parts, the county in and of itself could probably take action, but we have authority based on non-compliance with all other applicable laws, such as the Safe Body Art Act. For violation of that, that would too be a violation of our code, and we could have responded accordingly.
Thank you very much. I've just, another just general question. Are there legal businesses or businesses that are legal in the United States that raise concern about safety and health that we would not permit in the city of Cerritos? My question is simply, is there anything we would say, you know what, we can't have you here in the city of Cerritos? Is there a possibility, like, could we have that?
Well, I would go back to what I mentioned earlier. If is there a scenario where we would say, no, we can't have that business in the city of Cerritos? Possibly. If it's not listed in our municipal code, if it's as a permitted accessory, conditionally permitted, if it's not deemed a comparable use, and then in the review of the zoning code and potential impacts, I can't, it's all speculative, but I is there a scenario where I could see we would deny a use based on potential impacts, zoning law, et cetera? Possibly.
And again, if I could follow up on that, Commissioner, as long as the city has complete land use authority and there's no preemption or other issue like we have here, where there is the First Amendment that is implicated in this kind of use, and there's a proposed use that may have serious health concerns or be inconsistent with the uses that are allowed within our city, then the city the city could prohibit that use.
Okay, thank you. That was what I was looking for. Thank you so much.
Thank you, Commissioner Gandhi. I have a couple of questions. One is tagging along on what Commissioner Gill has mentioned. I need a little more clarification about the certifications and the licenses. So, are we talking about the license or the certification of the shop or of the workers?
Essentially both. The draft ordinance before you requires adherence of obtaining the health department license, and then it also requires for practitioners proof of a course. And I'll defer to Sabrina for further elaboration.
Sure. So there's two parts for LA County Public Health. First part is related to the opening of the business. So the store needs a public health permit. Then all your practitioners, anyone doing the act of tattooing, will need to be registered. And to be registered, there are state requirements that are mandated in state law. They need to take the approved course, and as well as provide proof of hepatitis B vaccination to be registered. And the county has a whole program where they need to provide all that information to them before they get registered. And if once they are registered, they'll get a little certificate that has to be posted, by their tattooing station, etc. So two portions of that. Does that answer your question?
So every worker will need certification.
Tattoo artist.
Tattoo artists. Okay. Are there any cities in California or outside of California that have prohibited tattoo shops?
So this, I'll start, and Attorney Erke can jump in. So this staff did a survey of surrounding cities and some local cities, approximately 30 cities. We did find that there were some cities that were silent on the matter. There were no regulations in their code that related to tattoo artists, to tattoo shops, or body art establishments. There were some cities that permitted it with a specialized type of permit that their city put in place. And then there were some cities, majority of the submitted cities that permitted it based on a conditional use permit. So those were the three responses that staff found in response to this type of scenario.
And if I may follow up on that, Chair, that's actually the issue that the Ninth Circuit Court of Appeals did address. An all-out ban and not allowing tattoo parlors anywhere in a city likely is unconstitutional. So if a city does have something on the books expressly prohibiting them anywhere in the city, that would be subject to a constitutional challenge. Yes, that's federal law.
Thank you. And I read somewhere that there are age restrictions. If the permit is given, there are age restrictions. What are the age restrictions
Well, pursuant to state
for
law,
the customers?
the client shall be at least 18 years of age to be offered or to receive a tattoo or permanent cosmetic application regardless of parental consent. And persons under 18 years of age shall not be offered or receive a body piercing unless the piercing is performed in the presence of his or her guardian. And there's some other state codes, but 18 is the age limit that was established in state law.
All right. So the main concern all along has been the health concern for such businesses. I wonder why for just the body art expression there has been so much of concern, whereas some businesses, though it impacts directly to the human health, are freely given licenses. Like, for example, businesses that sell alcohol.
I'm happy to address that issue. I mean, I know it's somewhat of a rhetorical question, but I think I can answer it at least from the from the legal side. Again, tattooing has bin found by federal case law to have a level of First Amendment protection. So there is that issue. Other items such as selling alcohol, which to your point, understandably, and can have other adverse health impacts, are not subject or have not been found to be subject to First Amendment protections. However, there are other constitutional amendments that address alcohol and leaving it to the states, and various states have different laws on the books on what they would and would not allow as far as the sale of alcohol and where to buy it. And that's actually through, again, federal case law based on federal constitutional amendments that have happened over the years. So again, what we're trying to address here is within the parameters of what federal case law has said in connection with tattoo parlors and the First Amendment protections that are attached to it and the inquiries we've received. We tried to focus on that, recognizing that in connection with body art, such as tattoo arts, there is reference and evidence of certain potential public health consequences if it's not done in a regulated manner or not done correctly. And that is a valid basis for having regulations. And again, that's a valid basis for imposing those regulations, notwithstanding that there is certain First Amendment protected characteristics to having body art and tattooing done.
Thank you. That anyone else?
Sorry, I'm just trying to understand the First Amendment involvement here. It says, the First Amendment of the United States Constitution, including any specific method of expression. Is that applicable just to tattoos, or we're talking about anything wider than that?
No, no, it's not just tattoos.
Okay.
There is a range of expressive conduct that has also worked its way through state and federal courts as receiving a level of First Amendment protection. That doesn't mean, however, that that type of expressive conduct, like getting a tattoo, cannot be regulated at all. They can be regulated. It's just that you have to allow for an ability to allow for that expression. And again, getting to the question on if a city were to outright ban it, is that problematic? Yes, because then you're not allowing any means for allowing that expressive conduct. But it is okay for cities to regulate and have reasonable requirements and regulations in place to address legitimate public health and safety concerns. But it's not just tattooing. There's a range of conduct that is expressive that may also have First Amendment protection that would also be subject to the same type of regulations we've presented to the commission tonight.
So it's an issue of regulation and not prohibition. Is that what I
Correct.
understand? Yeah, okay. Thank you.
Mr. Lido.
Thanks, Chair. I had a couple questions. The first question is at the March City Council meeting, and then for this Plan Commission meeting, was there any written or calls or any public comments from the general public?
For the item this evening, from the gentleman?
Or like from the public when this was on the agenda at the council meeting a year ago, and then up to this point with this meeting, has there any comments from the public?
For this evening, I can speak to this evening first. For this evening, there was one phone inquiry prior to release of the agenda report, and the individual just asked where in the city we were considering allowing tattoo establishments. We informed the resident where the proposed ordinance would allow, and that resident was fine and said she'd wait for the staff report, and if anything, she'd submit a letter. No letter was submitted because she supported the fact that the use was not around sensitive land uses. Other than that one call, no written or oral public comment was received by staff for this item today. And in March, when the city council adopted the moratoriums, I don't recall if there was any public speakers for the item. We did attach to that agenda report the letter from the attorney in January, but the attorney nor that business owner spoke at that meeting in March or is here tonight.
Thank you. And then my second question in regards to the Safe Body Art Act that was passed, because we had talked about certification for the county at the county level, but is there any administrative body, I guess, that at the state level, because there's like the barbering and cosmetology, for example, board that oversees barbering and then hair salons with tools. Is there any state jurisdiction on these kind of tattoo artists?
If the short answer is I don't know if there is a state agency like there is for cosmetology. I imagine this act, if there is a state agency that has oversight, that would be it. But I'm not sure if it is included. And the act itself doesn't expressly designate that. But what the act did allow for is for local agencies to have it. And so LA County has taken that on, and what we're proposing to the commission and what other cities in the county have done is defer and work with the county and have their oversight and their licensing provisions be the ones that would be, the oversight that would apply for cities within the county. And since the counties are the political subdivisions of the state, and they're there to implement, the state laws on a statewide basis, it may make sense that it's just county by county, and there is not a state agency that oversees it. I can look and get back to the commission on that, but I'm not aware of it at the time.
Thank you.
Anyone else? Any comments, any questions? No, there's one.
If there's no more questions or comments by members of the Planning Commission right now, although nobody's available, there could be somebody in the lobby. It would be appropriate for the Planning Commission to open public comments on this item.
Right, so having none, no public comments, do we have a motion?
I'd like to, I think we need to close the public comments, and then I want to ask a question. So if you want to close them, then I'll ask.
We close the public comment section at this time. Commissioner Gilles.
Thank you. So I just wanted to get clarity on what we, as the planning committee or commission, are supposed to be doing. So we're going to say, if we can make a motion, that motion would be that we're recommending that the city council approve the amendment to the Title 22, which says basically you're gonna update Title 22 to include under conditional uses the body art businesses, item 17, and it's going to be based on the provisions of Chapter 2246. That's all we're really saying when we make a motion, that we agree that it should be part of the conditional uses, and we put it forward to the city council for them to do the next step. Is that a synopsis?
Yes, that is correct, as the recommending body to the city council.
Okay,
Correct.
So it's not in our purview to, we like it, we don't like it, we want it, we don't want it. This motion is just about updating the land use under the conditional use to add that type of business.
Within the MC2 zone, yes.
Okay. That's all.
Thank you. Commissioner Gandhi,
Yeah, I'll make the motion to approve.
do we have a second?
A second.
Thank you, members of the commission. I have a motion made by Commissioner Gandhi and a second by Commissioner Byrd to waive full reading of and adopt a resolution of the Planning Commission recommending that the Cerrito City Council approve Development Code Amendment 2024-1 as described by Vice Chair Gilheis. At this time, I'll go ahead and take a roll call vote. Commissioner Byrd,
Yes.
Commissioner Gandhi,
Aye.
Commissioner Polito,
Yes.
Vice Chair Gilheis,
Aye.
Chair Javeri.
Yes.
Motion carries by a vote of 5-0. Thank you.
Next item on the agenda is reports from the Department of Community Development.
Thank you, Chair. I don't have anything to report this evening. Thank you.
Next, reports from the Planning Commission.
I have no report. Just want to wish everyone a happy new year. Thank you.
Yep, nothing to report. Just wanted to wish everybody the best of years and a happy new year to everyone.
Gillies.
No report. Thank you.
Commissioner Byrd. Well, we are at the end of our meeting. I wish everyone a very happy, healthy, and peaceful 2024. Thank you. The meeting is adjourned.